Thank you, Your Honors.
Next case is GMPF Framing versus Villages at Lake Lily.
May it please the court? My name is Alex Finch and I represent the appellant GMPF Framing in this matter. The court obviously is aware of the record, can tell from previous oral argument. I'd like to touch on a few of the main issues that are presented within the briefs. First, the issue of unjust enrichment. At the trial, the court, when it entered, first of all, the standard here today is for one issue, de novo, and for all the rest is substantial competent evidence within the record. The court did not make any findings of fact in his ruling. It was just a straight denial of both the motion to conform the pleadings and for all claims at trial. The court found that there was no unjust enrichment for the appellees in this case, basically based on the Blum case, which is the 5th ECA case here involving a homeowner who paid a certain price to have his house built, and a framer didn't get paid, yet the homeowner paid the full price for the house. So the Blum court decided at that point that, well, if you've paid for everything, then there's no unjust enrichment and that claim cannot follow. Well, the case we have before the court today, it doesn't involve a homeowner and it doesn't involve a simple contractor. Either it involves a...
Relevance of whether it's a homeowner or a commercial development.
Well,
isn't the principle the same? How do you measure what would or would not constitute unjust enrichment?
we don't believe so, Your Honor, because in the context of this commercial action, in the Blum case, it was a set price contract. $300,000 for my house, for instance. In this case, it was a $60 million contract that they drew from depending on what the cost of the contract turned out to be. And in a massive contract of commercial of $60 million, there were multiple change orders. In this case, there were time delays. They advanced the schedule. My clients were supposed to be putting up framed prefab framing. They changed that to building framing, so the costs went up. So if the issue is, do we pay whatever the contract price is in a commercial context, it's very easy to, we'll build a bigger, shinier gazebo than we had before and eat up the cost of the contractor to buy any claim.
So is the distinction residential versus commercial, or is it fixed price versus open price?
I think the latter, Your Honor.
Okay, so if it was a commercial project for $12 million, but it was a set $12 million, then the Bloom case would apply?
I think arguably, Your Honor, because they're confined to that amount.
And if it's a residential home, which could have change orders, what's the relevance of, you said there were change orders along the way, there could be change orders in a residential contract too, right?
Yes, but the potential for that is much smaller, Your Honor. You have to look at on a policy level, as demonstrated by this particular case. The Blum case was the whole contract in total, and the subcontractor argued the framing. The appellees have argued the reverse here. Oh, well, we overpaid on the framing contract, but they had $3 million left on the whole contract. They had contingencies for liens in each portion of the contract for framing, block, whatever it may be. In this case, we had a $178,000 contingency holdback fund to pay liens for that issue. So here the whole contract was never expended, and the Blum ruling is if you expend the whole contract and there's nothing left, then we're going to find unjust enrichment. I don't necessarily agree with that ruling, but that's the one.
Prove to establish unjust enrichment. What were your elements to prove?
That a benefit was provided that the party against whom the claim is sought accepted the benefit and received a benefit for it, that I was not paid, that the appellee was not paid for it, and in this particular instance, according to the Commerce case cited in the appellee's brief, an affirmative obligation to show that the entire contract was not paid. That seems to be the elements for the claims of unjust enrichment in this context, Your Honor. And we felt we met all of those. The court clearly found that we did work that we weren't paid for, that GMPF was not paid for. I think the court said did good work that was not paid for. The vast testimony in the record shows that when the contractor was expended, it wasn't to do GMPF's work over again. It was to speed up the process. There were delays. It slowed down because we weren't using prefabs anymore. Now we're building out the framing individually. GMPF was a smaller company and didn't have the manpower to increase its schedule. Plus, they didn't get paid for the work they'd already done, so they couldn't pay their laborers.
But the price to complete the project cost more than the original contract price, correct? Isn't that
No,
what they understood, that they-
Framing portion,
The framing portion?
the framing portion, I think you say.
Yes, because there's two separate contracts that are been raised in the briefs. So to the extent that it was the framing portion, I think the answer to that is yes, because, excuse me, they advanced the cost. They had to hire new people to replace not only my client who was thrown off the job, but the contractor who became insolvent. They had to replace that person too.
So
With
it did
those
cost
costs.
more, but in order to recover, I mean, this is a partial performance. I mean, GMPF performed about 70% of the work, correct, before they stopped? Because they
On one,
completed their
they had a
contract.
contract for 3 phases, Your Honor. This is the first phase, and when they stopped performing, it was an anticipatory breach on behalf of Reliant. They wouldn't pay them so they could pay their laborers. And then they advanced the schedule beyond what the original scope was under the contract.
But
So I
on a
would,
partial performance, don't you have to show that, in order to recover, that the contract was performed for less than the contract price?
our portion was
Complete the project for less than the contract price.
at the time of the notice by GMPF, the contract had not been fully paid out. There was still a balance left on the contract. I believe $700,000 was left on the balance of the contract when the notices at issue here that ultimately turned out to be
But still work to
imperfect.
be completed as well, correct?
Yes, and that's the issue. What work? It was work beyond their original scope because they changed in mid-plans. And because it started raining, so we had to bring more people in. We had to fix things. We had to have machines that come in and dry out the property, all those types of things. And there was a contingency for that. That's why they had a $60 million contract that they only used 57 of. They anticipated problems. So what's to stop a commercial from making a lowball contract offer on a contract and then changing everything to raise the price of everything and not paying someone and saying, oh, by the way, we just expended under the contract because we changed the contract, so you no longer have a claim. That would put a whole lot of power into the commercial
That's why we
contract.
have statutory liens, right?
Yes, but we're not here on a...
Deadlines like you're supposed to, you don't have those problems, right?
That's right, Your Honor, and if everybody did this, then we'd never have a body of law for equitable liens, and we would never have this discussion. But we do have this discussion. And in the Crane Court, Crane versus Fine, when you get to equitable liens, that whole law is based upon if somebody blows it under their statute. My client blew their rights under the statute, undeniable. But were there special circumstances that allow them to proceed against someone else? Yes. The issue in my client's case is almost identical to Crane versus Fine. What did we have there? Somebody who had, the Crane versus Fine case, the notice was improper, causing the lien to be no good. In our case, the only real distinction is we had a good lien, and then the GMPF failed to respond to a notice of contest of lien. So they blew their right for enforcement of a valid lien. Next, we had an insolvent contractor in Crane. We have an insolvent contractor here. The owner in Crane knew of the contractor's insolvency. It's replete throughout the record that Villages and Morgan knew that Reliant was insolvent. In Crane, we had a $15,000 holdback fund. In this case, we had $700,000 left on the contract, $178,000 holdback at the time of the notice, and $3 million left on the construction funds at the end of the contract period. I'd like to point to the court that the time to determine when there's an available fund isn't at the end of this case, because they would just expend the money. Both the fourth and the third DCA have decided that when do you determine when there's an available fund? It's at the time that the notice is given, even if it's an invalid notice. And those two cases are Royal versus Clemens, 394 Southern 2nd, 155, and that's a fourth DCA case, and Peninsular Supply Company, 423 Southern 2nd, 500, that's the third DCA case. The fifth, based on our research, does not have a case establishing the time for determining the availability of the fund. But it would make sense that it can't be at the end of the case. This is 7-year litigation for the court. It's easy to expend those funds within that 7 years.
Well, what date were the funds depleted in this case?
I'm sorry, Your Honor, I didn't understand the question.
The funds depleted here.
Which funds? The funds on the contract for the framing, Your Honor? Or, sometime after my client was off the job, within probably this first 6 months at completion of the first phase. The funds in the entire contract were never depleted. So we'd suggest that, in our brief, Your Honors, we cited cases where each time that there was an insolvency of a contractor, that circumstance with availability of a fund constituted a particular circumstance that would allow the court to, Your Honor, to apply an equitable lien. The appellee has no case to the contrary. The appellee just wants to say, well, you have to have unjust enrichment also. Well, that's not what Crane versus Fine says. By there being a fund, what Crane versus Fine says is you have to have a fund to go after, whether it be a property or some sort of monetary fund. But specifically in the Crane versus Fine case, the defendant wanted to say, the contractor wanted to say, the owner, we're innocent, and if you make us pay this, then we're going to have to pay twice. That's unjust. And the court said, no, you're not innocent. You knew of the insolvency, you had a copy of the notice, same thing we have here, and you paid anyway. So you're not innocent, and it doesn't matter if you pay twice again. Well, if unjust enrichment is a prerequisite for exercising the court's general ability to impose a lien based on general considerations of equity and justice, then that wouldn't be the case. You certainly wouldn't have to make somebody pay twice for something.
What were you seeking to impose an equitable lien on?
Specifically within the pleading, it was real property, but within the prayer for relief, it was a general, it asked the court for general relief of any equitable relief.
Well, to get an equitable lien, it has to be a lien on something, right? If you're just asking for a money judgment, then that's not an equitable lien claim. That takes you back to your unjust enrichment.
Yes, sir.
You have to have something to apply the lien to. Correct?
Yes, sir. First, it was the pleading stated for real property. Throughout the argument of the case, summary judgment and those issues, it became whether or not there was a fund available.
Did you establish that there was a fund against which the lien could be applied?
Yes, and we've discussed that in oral argument today. At the time that the notices were filed, an available fund of $100.
Now you're asking the court at trial to impose a lien. How do you impose a lien on a fund that's no longer there? I mean, if they had sold the real estate before you filed your lawsuit, you couldn't get a lien on the real estate, right? Because there was nothing to attach the lien to. What was there in the way of a fund at the time of trial to attach a lien to?
Well, again, I would disagree with the court that there has to be an existent fund at the time of the lien, and that's what Royal versus Clemens and Peninsular say, because they have that standard. All you have to do is spend the money, and you automatically defeat an equitable lien on a fund. But to answer the court's point, there's $3 million left undispersed on the entire construction fund. And if you go to Bloom, it's not about the individual framing contract, it's whether there's extra money available to pay. The final thing, Your Honor, if I could move forward, is the argument about the damages. Appellees made a lot of argument about, we didn't prove your damages. And they continue to use the standard for a breach of contract. And all the cases cited in their brief, they use the standard for a breach of contract, profits plus what you expended. We don't have a breach of contract case. We have a quantum merit case. Quantum merit is the reasonable value of the services rendered. And the parties agreed to that reasonable value through sworn statements that were signed off on and paid. At the end of the day, they decided not to pay for one of them. And they withheld the retainage, they withheld the payment. It was a $48,000 check, $33,000 in retainage, and then there were 2 change orders for $28,000, 16 of which was actually paid. So it's really about a $13,000 there. So damage were proven under the standard required both for unjust enrichment and for an equitable lien to determine what the lien value would be. It's not the standard of, they want to argue, well, you had a prorated percentage thing, that's how you get your draws. Well, this court, the 50CA has determined that in Boyce Construction Corporation, 414 Southern 2nd, 634, they cited with approval another case in which the Davis case, when they noted that in quantum merit cases, a prorate, percentage completion of a contract in a construction thing is sufficient measure of damages under quantum merit. So my client proved their damages completely. There's no dispute as to the lack of payment to them.
You also asserted an equitable lien claim against Morgan, is that right?
Yes, sir.
Attempted to, although it wasn't pled, is that right?
Yes, sir.
Was there an entity to attach that lien to against Morgan?
I'm sorry.
What would the equitable lien against Morgan be attached to? Did Morgan have funds to attach the lien to?
Yes, Morgan retained the money that was supposed to go to my client and never had to pay that out. It's important the court aware, my client, the services that my client provided were never paid to anyone. All the additional funds were for bringing in somebody else to advance future work under the contract.
So the retainage is the fund you were seeking the equitable lien against?
Yes, and they maintain that contract fund, Your
You've got
Honor.
about 2.5 minutes left. If you
So I'd like to yield the balance for rebuttal.
Okay.
Thank you, the court, for its attention. Excuse me.
Morning. May it please the court, my name is John Daniker from Schutz & Bowen in Orlando. I have with me today some folks who are considerably younger than me. I have Will Matthews, who started with us about 2 years ago, Jonathan Lawler, who passed the bar in October and joined us, and then Kendra Gow, who was our paralegal at trial. It was her first trial overall, and this is certainly her first oral argument. So they're here just to see the finish line, hopefully. If you don't mind, I'm going to reference the owner, the then owner of the property as Villages, and then the general contractor as Morgan. I was fortunate enough to get to have tried this case with my partner, Glynis Rubin, and that gives me, I think, an advantage over sometimes when appellate lawyers step in and have to read the transcript cold. And I can say to you that the evidence that is presented in the appellant's brief and reply brief, and then the summary of the evidence that was given to you just now is markedly different than what you're going to read in the trial transcript. And I'll go over a little bit of that. I want to start with talking about some of the salient facts. I want to delve into the damages methodology used by the appellants at trial, and then I'm going to go over the case law. I've practiced construction almost exclusively for 28 years, and this is what I live and breathe and have the fortunate opportunity to speak on throughout the state. So I could spend all day talking about those issues, but I wouldn't dare do that to the court. This project, and I say this in all due respect, was not extraordinary. It was not extraordinary. It was a construction project where there were fights that happened every day on every single construction project, and this one in particular was no different than things I see throughout. What was extraordinary and what remains extraordinary about this project is the extent to which GMPF believes the law and this court and courts at the trial court level owe it obligations that are, I will consider to be unprecedented. Extraordinary, and rightly and properly rejected by the trial court, and I'll explain why. So here's what happened. As the court knows, GMPF was a framing subcontractor. It was hired by Reliant. It was a turnkey project for Reliant. And a fight developed, as happens on almost every project I've ever been involved in. The fight was over the timeliness of the work, the quality of the work. The fight, of course, was over whether some work was change order work, and if so, what was the amount to be paid. And the court will note from the record that there is substantial evidence that GMPF was not lily white on this project. They failed inspections. There were inspections that were observed by our project executive, Corbin Johnson, that were strictly the fault of GMPF. But we don't need to get into that. The fact of the matter is there were fights, and they were brought to the lap of my clients. In July of 2008, Reliant had already started to supplement the forces of GMPF. Supplementing meaning we have to bring on other folks to help you do your work because you're not getting it done on time. And along with that goes the writing of a check to pay for that would reduce GMPF's work they had to do, but also their contract balance.
Was that a speed up of the deadlines, or was it consistent with the original deadlines in the contract?
The speed up of the deadlines was in part due to failed inspections. It was due to failed inspections. The inspections that were failed were at the original project engineer level. The project engineer would do a pre-inspection, which is not uncommon from a structural standpoint, and then require things to be corrected prior to the formal inspection by the City of Maitland building inspector. As early as in September of 2008, GMPF wrote a letter to Reliant saying, I can't staff this project the way it needs to be staffed because I have not been paid by you on another project, and it's talking to Reliant. So there's an admission in the record that it can't furnish the workers that are needed to advance the construction schedule, not because of anything that Villages did or that Morgan did, but because of a fight on another project that was completely and wholly unrelated to ours. As the court knows, in September 18 of 2008, Morgan tendered a joint check to Reliant to in turn be endorsed and given over to GMPF. That is a very common way that owners and GCs in Florida make what is called proper payments under the lien law. That's a payment that ultimately makes it to lienors who have properly give notice. As the court also knows, Dutch Holt, the principal of Reliant, said, I'm not going to sign it over. I'm not going to sign that over. I'm not going to give it to him. And in Trial Exhibit 35, Mr. Holt explained the reasons why. And in that communication that he sent to Morgan was a dialogue about all of the things that GMPF had done wrong or had not yet done, and the fact that he believed they were going to walk off the project because they didn't have the staffing to finish it. Corbin Johnson, this is important in terms of this court's equity jurisdiction. Corbin Johnson, again, our project executive, called Mr. Ledford, who was the principal of GMPF, and personally offered to host a meeting to try to resolve this dispute between Reliant and GMPF. And Mr. Ledford, I'll give him this, he was candid during trial, and he said, I didn't show up. I didn't show up. On September 24, the first day my clients were notified of this fight, GMPF recorded its lien. First day, it's the same day, by the way, as I noted in the brief, that they wrote a letter to us, GMPF wrote a letter to us saying, hey, we've got a fight going on our hands. GMPF abandoned the project. Mr. Finch said kicked off. They weren't kicked off by anybody. They left. They certainly weren't kicked off by my folks. It's another instance of where the trial transcript and arguments and characterizations don't necessarily match. GMPF's lien, and this is important, initial one was for $118,634. Of course, you know that Reliant hired Bob Warman, a friend of mine, filed suit to discharge the lien. The law requires that you respond with a counterclaim or a separate filing of a lawsuit to foreclose the lien in 20 days. It's jurisdictional. You don't do it, you're done. As the court knows, GMPF was undeterred. They filed a second lien for $90,000 this time. The court entered a judgment on the pleadings saying, hold on a second, you've already lost on this. It came up before this court. This court affirmed the discharge of that second lien. Then, when Reliant filed bankruptcy, GMPF turns its sights exclusively on my clients because we were the only entities left standing. The legal title to the theories that were pled, I'll call them, they give them undue sophistication. Because if you look at the trial testimony of Mark Ledford, GMPF's principal, it's pretty clear what they were doing. And I'll try to explain it as best I can. At trial, Mr. Ledford said, in response to my questioning, Morgan, the general contractor, should have overruled Reliant's objection to the payment, that joint check, and paid GMPF anyway, right there on the spot. He also said Morgan should have taken GMPF's word over the word of Reliant. And so we can slap titles like equitable lien and unjust enrichment and whatever you want to call it. The fact is, the position of GMPF during the project and the trial court level and in front of this court is we are to ignore all of our proper payment obligations. We are to ignore our subcontract agreement. We are to ignore the Florida construction lien law and pay them whatever they think is owed and then deal with the consequences later, and there would have been consequences. If Morgan, and this is important, had paid in September of 2008 what GMPF was then demanding, and this is undisputed, it would have paid twice for the roof crickets. Those are basically saddles that go next to a chimney or something to cause water to run off and not dwell near something and cause rot. It would have paid twice for the parapet walls. The parapet walls were always shown in the drawings. They were always in Reliance subcontract. They would have never been a change order to Morgan, the GC or the owner, ever. And there was a fight between Reliant and GMPF as to whether they were in GMPF scope. But yet, GMPF wanted us to pay for those. They wanted us to pay for the crickets that we'd already paid for. We would have paid $118,000 had we acceded to their demand at that time and put caution in the lien law to the wind. And then later, we find out that a second lien for $90,000 and 631 cents is now the amount owed. So had we paid the $118,000, we would have overpaid by $28,000. Reliant wouldn't have given us a coupon for Bed Bath & Beyond to go spend that. They would have said, you overpaid. Tough luck on you. GMPF would be okay with that, by the way. But then the amount changed again. When we sent interrogatory answers to GMPF in the case, then the amount then became $110,000. So we go from $118,000 to $90,000 to $110,000. And yet, they don't back off in their position, pay us what we say we're owed, and if you don't, you've been unjustly enriched, and we're entitled to chase you for 6 years in litigation. And then another striking thing happened. At trial, Mr. Ledford said, well, the amount's now $134,000. So now we have our fourth amount that they say is owed. And then, in cross-examination and listening to the testimony of our witnesses, he realized, hold on a second, I didn't do the crickets. I only did 2 of them. So on the stand, he again changed the amount to $126,000. 5 times. And that may seem trivial in the context of complications of calculating construction damages. It's not trivial when they want to seek to impose a lien on a specified fund in an amount they can't even figure out until their reply case in trial. The damages calculations are not to be discounted in terms of how they are to be determined. We didn't use a breach of contract theory. We used the theory that is required in quantum merit cases, and you'll see in our cases that those are the contexts, sometimes in privity with the entity that is being sued, sometimes not. But the theory is a partially performed agreement of whatever sort. If you haven't finished your work, now the court knows about the substantial performance doctrine, and that is where you do get to say, my contract was for $100,000, now you have to prove your offsets. 70% is not substantially completed, it's not substantially performed. So the case law is clear. It's absolutely clear that you have to prove your reasonable expenses, what your profit would have been. And then, of course, we get to offset what we paid. I spent an inordinate amount of time giving Mr. Ledford chance after chance after chance to tell me that his damages methodology was not percentage of completion. And consistent and truthfully, he said time and time again, yes, that is my methodology that's used. The D.D. Jackson case that we cited in our brief, the Puya versus Superior Pools case, the Nico Industry case, they all say that is an improper method of calculating damages on a partially performed construction contract. And Mr. Finch can stand before you and say what he wants. What he won't be able to do is cite language from a case that says anything to the contrary. Now, the court, perhaps in hindsight, gratefully or graciously denied my motion for involuntary dismissal on that and other grounds. It would have given us a harder standard to sustain on this appeal. But the fact of the matter is, it could have and should have been granted because they did not prove their damages in a legally permissible way. And the Allard versus Nyam case that we cited in our brief makes clear you don't get a second bite, in this case, fourth bite at this apple. If you don't do it right at the trial court level, you don't get a rehearing where the case is sent back down for you to fix your problems in terms of your proof. Let's talk about unjust enrichment. You might have noticed it was unintentional, but perhaps it was a nervous twitch when I hear comments about a fund for, a contingency fund for liens, about $3+ million that's undispersed. And having been there, I know what the record showed, and the record showed that the money that he's talking about was there at the end of the second to last draw, not the last draw. They didn't prove what money was left over whatsoever. And the money, more importantly, was uncommitted loan funds. Uncommitted loan funds. Our treasurer, Stan Levy, testified that that money was for interest reserve that the bank required. It was for tenant build-outs that had nothing to do with their work. It was for a host of things. He never said it was for paying liens. But perhaps a more transcendent inquiry is, where is the case in Florida? And I've had my home renovated a couple times, and as you can imagine, the fear of the contractors working in a construction lawyer's home. But where's the law that says an owner is obligated to borrow money that it has to repay to satisfy an equitable lien claimant's monetary desires? Money that you have to repay, which this $3 million, $10 million, $100 million, whatever it is, I got to borrow it and repay it so that you get paid when you didn't perfect your lien rights. There's not a case in Florida and probably in the country that says that you have to do that. So
The construction contract itself, a fixed price contract?
it was absolutely a fixed price
What was
contract.
the fixed price?
It was, I want to say it was around $60 million, Your Honor, but
What was spent?
the entire contract price was spent. It does get increased with change orders. Every project has change orders. What the actual amount was, I don't recall. It is in the testimony, and there is a spreadsheet that was done by Corbin Johnson that recapped the expenditures, and Mr. Levy testified about that as well. But we had our expert, Bob Scales, who's a general contractor and has been for a while, that has had his own framing company and has priced such things. He testified that Morgan paid to Reliant all of the framing subcontract price, and that Villages paid to Morgan all of the construction contract price. And there wasn't the crust of the bread left over to pay GMPF. There was nothing left. And I don't even know if there was contingent money left with loan conditions that could have been dispersed. We never got there because it wasn't our burden of proof to show that. So all of this, of course, in the majority of Mr. Finch's argument, was about an equitable lien upon funds. The first time that concept was mentioned at the trial, I objected in my obnoxious and self-righteous way, and the court went ahead and conducted the trial as he was obligated to do. But the fact of the matter is, had that been pled previously, there was a lot of things we could have done and would have done had we known that they were chasing that money. First of all, he cannot dispute that the money he's talking about, at the time he was talking about it, was held by the bank. It wasn't money that was ours, it was held by the bank. And for us to get that money, of course, those of you who have been involved in major commercial construction projects, you don't just pick up the phone and say, hey, Hal, send me 10 million, I'll tell you why later. I mean, you gotta cut your wrist, and you gotta sign it in blood, and you gotta make all kinds of promises, and you have to prove that it's being spent for a specific reason, and you have to prove that you're not borrowing money from A to pay B. So it's not a given that we could have even gotten this loan money that he talks about, but even if we could, you've seen plenty of cases where in undispersed funds like that, the lender is a necessary and proper party because they're holding the money. They're holding the money. And then you have to prove that the lender got an unjust enrichment, that the lender got a completed construction project that has equity in it, and it got that equity because it didn't pay, it didn't disperse all the loan proceeds. There was a statute of limitations argument we could have asserted. An equitable lien, as the court might know, under, I can't remember I can't remember if it's in 713 or oh, you know what, it's in the 9511. It's 1 year from the date of your final furnishing. It's 1 year. When we tried this case, we were 6 years from their final furnishing. So I might have had an epiphany and thought, oh my goodness, if I'd known they were going to sue us for this, we've got that argument to make. All of these things we could have made, and we didn't because we didn't know it was going to be an issue. You've seen the case law in our brief. To the extent that there's a claim that we didn't contemporaneously object, well, I did the first time the phrase or concept was mentioned. But the case law is pretty clear that if the evidence that's submitted also goes to other relevant issues, which in this case, unjust enrichment would have been one, then there's not a waiver whatsoever. So what's the causes of action pled? The cause of action for equitable lien on real property, I don't know if it was abandoned. I sure didn't hear much about it just now. I can say two very global comments that I think might save me some time here. One is there was no pleading and there's no proof of fraud, deception, reprehensible conduct, or any of the kind of conduct that would suffice to warrant imposition of an equitable lien on real property. Wasn't there. I think Mr. Finch even admitted in his closing argument, well, we didn't have that kind of evidence. Second is, at the time of trial and long before the trial, there was a new equity owner on the property. So, and Judge Stroker kind of musingly said, wow, I'm in the real property business. It would scare me to death to know that somebody could swoop down after I bought something that's not of record and impose a lien on it. That would bother me too, by the way. Let me close with this because I'm running out of time. Having done lien law for as long as I have and it costing my hair and the color in my skin, I have a pretty good knowledge of it. And the relief that's sought by GMPF would put the lien law, would turn it on its head. You could never, as an owner, ever be sure that you're not protected from claims far down the road based upon equitable principles, even though you've paid in full everything you're supposed to pay. And how are lenders then going to be safe? If we can't rely upon releases, if we can't rely upon judicial discharges of liens, how are we ever sure that somebody's not going to jump out of the woodwork and encumber property like was done here for 6 years? And I can't imagine what my life will become. I'll probably retire early, as I will with this argument. Thank you so much for your time.
May it please the court. I was also trial counsel. I was there and I read the transcripts. I have the same view that opposing counsel has. First, the argument that GMPF was not Lily White, that's an estoppel, unclean hands argument. This court has a case that says contractual disputes are not enough to create unclean hands. They have to do something wrong. The only thing they alleged was you didn't do good work. So, like anybody, that doesn't make him any more clean or dirty than anyone else. Counsel, in response to Judge Palmer's question, what caused the delays? And counsel said failed inspections. Notable within the record is not a single failed written inspection. The testimony of the inspectors for Morgan testified that that the work was good and they did not find failed inspections. That's a red herring, that's a fallacy. There was no proof whatsoever that any inspection was filed. That's why Judge Stroker said they did good work that they weren't paid for. Counsel stated there was a judgment on the pleadings. That's not the case. We did have a prior hearing. My client amended its claim of lien, and there is some case law in the law that says that is sufficient to refile beyond a notice of contest of lien. But there's been no judgment on the pleadings at any time where the merits of this case were heard, other than the trial that's before the court today. Counsel is incorrect that he objected. He raised the issue to the equitable lien fund when the evidence was being presented, and they presented it, mind you. No objection was made. It was only made during a motion for directed verdict or involuntary dismissal, and in closing. There was no contemporary objection, no ask for it to be stricken, nothing. It was absolutely waived under the law for conforming pleadings. And finally, as to imposing something on an equitable lien on real property, the counsel said, we don't have any reprehensible conduct. Yes, we do. The conduct is the owner, with full knowledge of the insolvency of the party, chose to pay someone else when they knew the work was already done and there weren't any inspections. That's reprehensible conduct. It doesn't have to be mistake, fraud, or misrepresentation. There's reprehensible conduct. My clock's going a little crazy here. I'm going over time. So I thank the court for its time and consideration. We ask that you reverse and for judgment in favor of GMPF. Thank you.
The court will take its morning break at this point. If you'd like to join us in the lawyer's lounge, you're welcome to join us.